Let me also now go across to Sanjay Hegde, also joining us over the phone line. And Sanjay Hegde, a big decision coming in from the Supreme Court, staying the sedition, in fact, law for now till July. What does this really mean for all those cases that have now been lodged across the country?
No, as far as all the cases that are lodged across the country, the court has made it clear that people are now free to approach trial courts for bail and has requested all the trial courts to expedite those bail hearings. So the technical position is that the law currently remains suspended. Therefore, prosecutions under it should not continue till a relook happens, and no fresh cases should be registered. That's the third part of the order.
Right. But, sir, what is being said by the other side, saying that there are over 800 cases of sedition that are filed across the country, as many as over 13,000 people are in jail. So what is the point of view earlier was given by Mr. Sibal was that complete striking down of the law altogether because of its colonial nature, and independent India does not need it.
Well, there are two questions in what you're asking. First is whether India needs it or doesn't need it, and whether it is constitutional. The legislature normally takes a call on what laws have to be passed. The courts take a call on what is constitutional. It may be argued that this law was upheld earlier in 1962, 60 years ago, as being constitutional, but the constitution has also evolved with the times. Today, the Prime Minister has said that there is going to be a relook at the law. The Supreme Court has taken note of that and said that while you're relooking at it, as far as the present situation is concerned, let it not be exacerbated. So don't file fresh cases. As far as the pending cases are concerned, let everybody approach the courts and their bail applications will be heard.
In fact, Mr. Sanjay Hegde, another question to you. The Supreme Court also mentioned the entire Chalisa Rao and how the Ranas have also been booked in Maharashtra. Do you think in the absence of the sedition law, section 153A might now be the alternative as far as the sedition law is concerned until June, as far as anti or hate speeches are concerned?
Absolutely. So that was precisely the objection also to sedition law, saying that it was OTOs, it was in excess. There are several other provisions of the IPC which can deal with most situations. So there is no real requirement to have a specific law which said disaffection against the government of the day by law established. You may have affection for a government, you may have disaffection for a government,
right,
but
sir.
can't you express it?
Right, sir. Mr. Hegde, thank you very much for joining in. Mr. Saugata Roy is also with us on the broadcast. Sir, what is your point of view as far as the Supreme Court there staying the law until further use till July, giving time to the centre to reconsider?
Yes, we are very happy with this law. You know that MP from our party, Mohammed Mutro, lost the case in Supreme Court to strike down Section 124, that is sedition law. The government was hesitating. At first it opposed. Then yesterday it said that no, they were changing their views. They were reconsidering the matter. We are very happy that Supreme Court has stayed the law till the government comes forward with the application. In an independent country, there is no justification for a sedition law, and all the people who were arrested under sedition law should be released.
All right. Thank you so much, Mr. Saugata Roy, for joining us here on this broadcast.